Yesterday I shared a short video about REITs. Do you want to know the details of the REITs? Today I will explain. I request all of you to listen to till the end of the video. What is a REIT? A REIT is a formal written order issued by a court to enforce legal rights and provide justice against violation of fundamental rights. In India, REITs are issued by the Supreme Court under Article 32 and by the High Court under Article 226. There are 5 types of REITs in Indian Constitution, and all the REITs are Latin. All the REITs are in Latin words. They are habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Let us explain these 5 REITs in details. Number 1, habeas corpus. The term habeas corpus, which means you may have the body. That means bring the body. Let us explain it. What is the meaning of habeas corpus? When a person is arrested or detained without legal justification, the Supreme Court or High Court can issue a writ of habeas corpus. The court then orders the authority or person who has detained the individual to produce the detained person before the court and explain the reason for detention. If the detention is found illegal, then court orders the person's release immediately. If we take the example, famous Ladakhi activist and educator Sonam Wangchuk on 26 September 2025 was arrested for demanding Ladakh under 6th schedule and as statehood. Following his detention under the National Security Act, his wife Dr. Gitanjali J. Angmo filed a writ petition under Article 32 of the Indian Constitution, challenging the legality of his confinement. The hearing is under now the jurisdiction of the Supreme Court. Let us move to the mandamus, the second writ. What is the meaning? The literal meaning of this writ is we command. We command means the higher authority commands to the lower authority. Let us explain this. The writ is issued by the court to order the public official who has failed to perform his or her duty or refused to do his duty. Besides these officials, mandamus can be used or issued against any public body, a corporation, an inferior court, a tribunal, or government for the same purpose. If we take the example, a well-known example is Prakash Singh versus Union of India in the year 2006. In this case, the Supreme Court issued directions to the central and state governments to implement police reforms and ensure proper functioning of the police system. The court issued the principle of mandamus to order public authorities to perform their legal duties and carry out reforms. Let us go to the third one, that is called prohibition. The word itself gives us idea, that is, it will say something about prohibit. What is the meaning? The literal meaning of prohibition is to forbid. Let us explain it. A court that is higher in position issues a prohibition writ against a court that is lower in position to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. It directs inactivity. Let us give an example from prohibition. One example is East India Commercial Corporation Limited versus Collector of Customs in the year 1962. In this case, the Supreme Court held that when a lower authority acts beyond its jurisdiction or contrary to law, higher courts can issue a writ of prohibition to stop further proceedings. Let us move to the fourth writ, that is called certiorari. Let us move to the fourth writ, that is certiorari, meaning the literal meaning of the writ of certiorari is to be certified or to be informed. Let us explain it. This writ is issued by a court higher in authority to a lower court or tribunal ordering them either to transfer a case pending with them to itself or quash their order in a case. It is issued on the grounds of an excess of jurisdiction or lack of jurisdiction or error of law. It not only prevents but also cures for the mistakes in the judiciary. Let us take the example. A well-known example is A.K. Kripak versus Union of India in the year 1969. In this case, the selection process for the Indian Forest Service was challenged because a member of the selection board was also a candidate. The Supreme Court held that the decision violated principles of national justice and quashed the selection, issuing a writ similar to certiorari to cancel the invalid decision. Let us move to the final, that is the fifth number of writ, that is quo warranto. And what is the meaning? The literal meaning of the writ of quo warranto is by what authority or warrant. Let's explain it. Supreme Court or High Court issue this writ to prevent illegal usurpation of a public office by a person. Through this writ, the court inquires into the legality of a claim of a person to a public office. Let's give the example. A well-known example is B.R. Kapoor versus State of Tamil Nadu in the year 2001. In this case, Joya Lolita was appointed as the Chief Minister of Tamil Nadu even though she had been convicted in a criminal case and was disqualified from being a member of the legislature. The Supreme Court questioned her authority to hold the public office and declared her appointment invalid. This is an example related to the principle quo warranto, where the court asks, but by what authority a person holds a public office. These five writs are the, you can say, these five writs are the main weapons for Indian citizens if their fundamental rights are violated. Thank you very much.